So in terms of familiarising people with the platform, I'm going to take something you can see here from the news section. So you can see how the platform is laid out, that you can see who's a member, the feed, the events, and we'll be looking at other weeks in the events section, a lot of interesting events, a lot of them webinars, international webinars that you can click into, and then announcements. And if you have your notifications turned on, you'll get those in the news. So I'm picking something that Sharon put up in the news. And this was an article from Australia on strangulation. It was just, I think it was a police report or a police article. And one of the statistics about strangulation is that if a person has been strangled by an intimate partner, they're 750% more likely to be killed by that partner. And there's a link there to the article, and I haven't put in the link, but there's some of the latest research on the topic, so I'll add that link in as well. But the one thing that the experts say is that it takes very little time and very little pressure to render a person unconscious, and that a small amount of pressure can slow or stop the blood flow to the brain, leading to irreversible damage. And so this is the important information, that there are serious short and long-term effects, physical effects, and of course then psychologically, strangulation increases acute and chronic fear. It's a very frightening thing for your airways to be closed or anything like that. And of course, that leads to increased control as well. And one of the things that is discussed a lot now is that the strangulation behaviour is normalised. We might turn off people's sound. Normalised as part of intimate relationships by violent pornography. And this violent pornography now is being driven by algorithms to children as young as 9. And I put a link in there just to a programme by Richie Sadler, which was done on RTE, Let's Talk About Sex, where at the end of that programme, the young people were talking about how normalised the expectation of young girls being strangled during sex, and they were very confused because they had been shown, they were looking at this porn, and this is what young boys wanted to do, and they were saying, well, if we agree with it, is that not consent? And I think even Richie Sadler was really shocked by where the normalisation and what has been normalised by violent pornography. And when we were talking about that yesterday, Kathleen here in the office said, well, if people don't know the implications and they don't understand the risks, that really isn't informed consent. And we know, we've seen over the years in court cases where it's been used as a homicide defence, rough sex gone wrong. And it's why it's really important in risk assessments to ask about, sexual pressure to do things you're not comfortable with, sexual assault, to ask about strangulation, because of the high risk 750% chance that if in an intimate relationship where there's domestic abuse and coercive control, if strangulation happens, the likelihood of that progressing to homicide is very high. And of course, asking those sort of questions, they need to be asked. We can't ignore them, but obviously you have to find a way of asking them that's appropriate. So I'm going to introduce now Niamh Maguire, who's the Senior Lecturer in Law and Research at SETU, and she's going to talk about her research, District Court Judges' Perspective on Section 33 of the Domestic Violence Act 2018. And I will stop sharing my screen so that Niamh can share her screen and present that information to you. Okay.
Brilliant, thank you. I'm just going to try and share my screen here. I'll share screen. This takes a minute to set up. There we go. Okay, I think can everybody see that? Good. Okay, so I'll start. So thank you. Good afternoon, I should say. Today I'm going to talk to you about some of the findings from a research study I did for the Sentencing Guidelines and Information Committee, which I'm going to call SCIC of the Judicial Council. Just to let you know, the Judicial Council was established in 2019, and the main functions of SCIC are to prepare draft sentencing guidelines, monitor their implementation, collate and disseminate information on sentencing, and conduct research on sentencing. In 2022, the SCIC issued an invitation to tender for a piece of research on sentencing in the District Court to researchers on the research register, and I replied to that, and my proposal was successful. So just before we get into the findings, I think it's important that you have an idea of the overall aim of the research. It had 3 aims. One of them is directly relevant to what we're talking about today. The first was to examine the issues of concern and challenges by the district court judges when sentencing generally in the district court. The second one was to ascertain concerns and challenges in the same judges' approaches to arriving at decisions in specific cases of relationship violence and abuse. And the third one then was to ascertain judges' views on how sentencing in the district court could be better supported by SCIC in relation to sentencing guidelines and sentencing information. Now, the aim that's most relevant to today is the second one, concerns and challenges of district court judges when arriving at a decision in specific cases of relationship violence and abuse. So the main research methods used to gather data to answer these questions were in-depth, semi-structured interviews and sentencing vignettes. And 20% of the sitting district court judges participated in the research, which is a good sample, 13 judges. So just to contextualize the research a little bit, I'm not sure how much people understand really about what Section 33 is and how that works. So I thought I will focus today just on Section 33. I won't be talking about Section 39 or 40, but I can take questions on that really if you'd like later. So protective orders, really. So under the Domestic Violence Act, you're probably all aware that 2018, there are a range of different protective orders that can be applied for in civil proceedings in the family law court, including a safety order, a barring order, an interim barring order, an emergency barring order, and a protection order. So a breach of the terms of an order is prohibited under Section 33 of the 2018 Act, and while the order is civil in nature, a breach of the order is a criminal offence. Section 33 provides that a person who contravenes an order commits an offence, and if they are convicted, they are liable on summary conviction to a Class B fine and/or a term of imprisonment not exceeding 12 months. So serious enough for a summary offence. Now, it's important to realise that Section 33 prosecutions are the main form of domestic violence prosecutions that come before the district court. And although these can be accompanied by other prosecutions related to domestic abuse, such as assault, criminal damage, sexual offences, we have no data on how often this happens. Notably, Section 6.2c of the same 2018 Act newly provided for the first time a prohibition on communication by electronic means with the applicant or dependent person, and this applies to protective orders. This will become relevant later in terms of what represents a breach and doesn't. So another important thing to highlight is the lack of a definition of domestic abuse in Irish law. And this is a significant weakness of the 2018 Act, that it didn't adopt a definition of domestic violence, and also particularly in relation to psychological and emotional violence. It doesn't specifically define them as domestic abuse. And whilst arguably you could bring these within, you could criminalise them within the context of coercive control, this offence, Section 39, coercive control, does not refer specifically to them. And so an opportunity was lost to signpost that psychological and emotional abuse within the context of domestic abuse is a crime. What this also means is that Section 33 prosecutions are based on individual breaches of the protective order. And so a pattern of abuse or control over time is not captured by this offence. The key question for the research was whether judges viewed physical abuse as more damaging than psychological abuse, and whether they adhered to an incidental rather than a course of conduct model of domestic abuse that accurately captures the reality of domestic violence for many victim survivors. Last point on the context here, the data deficits. You're probably all aware of these, but I thought it's important to say it. The Court Service does not publish information on breaches of orders under the Domestic Violence Act. So there's two important data sources missing. Firstly, there's no official data published on the sentencing of domestic violence crimes, specifically Section 3, and no data published on how often separate charges from Section 33 are brought alongside domestic violence perpetrators. I managed to get access to a small data set that a previous researcher had accessed, and it showed the following. In relation to Section 33 cases in the Dublin Metropolitan District in 2019, 80% of them did not proceed to sentencing. Almost one half were struck out with no reason. This indicates there is a massive rate of attrition for these prosecutions, and further research is needed to establish why this is happening. Okay. Partly common knowledge, partly not, but a major finding, I suppose, from talking to judges about this whole area was that a clear picture emerged that by default, more than design, in Ireland there are two different systems for dealing with Section 33 prosecutions. One system in which judges have full access to the original civil application for the protective order, and another in which they have no previous knowledge of the family law file. So typically in provincial districts with one assigned judge, that judge deals with the family law and criminal law aspects of the case involving allegations of domestic abuse. In larger jurisdictions, for example, in Dublin, specialised courts such as the Dolphin House Court hears applications for protective orders, and there are then some specialised court lists dedicated to hearing breaches of these protective orders under Section 33. So really, I suppose this becomes important later to understand some of the bigger implications, some of the divergences in approach. So in really what you have is a judge in outside of Dublin, typically, you'll have the same judge dealing with the family law application for a protective order and the breach, whereas in other larger jurisdictions, you will just have that case, that Section 33 breach will be coming cold to the judge and they'll have no prior involvement. Okay. So we'll come back to that in a little while. I'm going to look here. Judges weren't specifically asked how they define domestic abuse, but through discussions of various Section 3 case examples, it emerged that most recognise that domestic abuse could present in many different forms, including physical violence, choking, criminal damage, including damage to windows and doors, watching, stalking, verbal, emotional, and psychological abuse, controlling behaviour, financial control and coercive control, abuse of trust and harassment, texting and emailing in circumstances where protection order prohibits communication. So most judges recognise that a lot of different types of domestic abuse, but not all judges mentioned all behaviours, and most commonly, there was a clear tendency among some judges to see physical assaults as more serious than other types of domestic abuse. And this was illustrated to some extent by the distinction some judges made between technical and serious breaches of protective orders under Section 33. But I have to say this was not widespread, and indeed some judges were well aware of the impact of psychological abuse and that it can be as harmful as physical abuse. So just looking at what judges felt prior involvement or lack thereof added or didn't add, and their views on whether Section 33 was similar to other types of criminal offences. So judges expressed mixed views regarding prior involvement, with almost equal numbers believing that it makes no difference. It helps and does not help. Some with prior involvement argued that their prior knowledge was irrelevant, as they can only take into account evidence related to the actual breach before the court and cannot consider other previous incidents or a pattern of previous abusive or aggressive behaviour. This clearly underlines the fact that Section 33 prosecutions are based on the incident and not the course of conduct model of domestic abuse. And the majority of judges saw Section 33 cases as different to ordinary crime for a variety of different reasons, although many related this to the nature of the relationships involved and the sensitivities and vulnerabilities that this gives rise to. And of course, Section 33 cases, breaches thereof, are dealt with in camera. So that was used as another indication to judges that they are different from ordinary criminal offences. While an awareness of the sensitivities and vulnerabilities is hugely important for obvious reasons, Section 33 is a criminal offence, and it's important that judges approach the sentencing of Section 33 cases in a similar manner to the sentencing of other offences. That statement in itself can be controversial. As we will see a little later, judges sometimes adopt a family law solution instead of a sentencing approach to Section 33 cases. We're going to go now and look at the difference between technical and serious breaches from the perspective of judges. There was a clear tendency among some judges to see physical assaults as more serious than other types of domestic abuse, and this was illustrated to an extent by the distinction they made between technical and serious breaches under Section 33. This was not widespread, and indeed some judges were well aware of the impact of psychological abuse and that how harmful it can be. However, despite the newly included prohibition against electronic communications as conditions to be included in protective orders under the 2018 Act, some judges viewed breaches of communication conditions as more technical and sometimes not requiring a conviction. This relates to the fact that psychological abuse has not been criminalised in Ireland and that its damaging impact is perhaps less understood. While some judges consider physical abuse is more aggravating than psychosocial or emotional abuse, there was a strong evidence overall that judges were motivated in general to adopt approaches that they believed would protect victims. For the most part, judges were not in favour of avoiding a conviction in Section 33 prosecutions, but some noted in exceptional cases it might be appropriate, particularly if the victim requested it. Judges' motivations to protect victims was also evident from the fact that over half mentioned that they would routinely request a victim impact statement, and others would require into what the victim wanted to see happen. Furthermore, some judges noted that they routinely use conditions of bail or suspended sentences to secure compliance of the respondent with the terms of the protective order. So, as I mentioned at the start, I used sentencing vignettes. So there were 2 vignettes, basically sentencing stories, and judges were asked to think out loud and respond to those and explain their approach. And through using this method, it was possible to see that there was really 3 groups of judges in terms of they adopt divergent approaches. One group primarily adopted a family law approach, another group primarily adopted a sentencing approach, and then a third group adopted an approach where they would prioritise both sentencing and family law. So what did a family law approach look like? So priority would be given really, rather than to responding to the breach as a crime and applying normal sentencing principles, they would be looking for a family law solution and prioritising this. They might even adjourn the case to fix the family law issue. In all approaches, judges raise child welfare issues, in fairness, but the family law approach can be contrasted to the sentencing approach, because in the sentencing approach, there was a lot of talk of this being very serious, and sentencing principles were prioritised, and usually in these judges who took this approach imposed an actual sentence. A combination of some of them, a third group had adopted both. They tried to prioritise both the sentencing and the family law approach. And I suppose generally overall, the conclusion I came to was that it's really important that guidance be given to judges as to what should be the appropriate approach. And I suppose this has never been done. And probably because there's kind of a split system where sometimes judges have heard the family law case as well, whereas other times they haven't. That probably contributes to it. But it's up. That's something you can ask or discuss later. Whether should we be seeking family law solutions in relation to a criminal offence or not? Two other important things that came out in the research through the vignettes was the importance that judges can place on mitigating factors, being living arrangements. So if a perpetrator agrees to move out of a shared home, then judges will see this as a protective factor and potentially reduce and increase the safety and reduce the harm to the victim. So they will see it as a mitigating factor and maybe reduce the severity of a sentence altogether if there's an agreement. So key question is, should this be the case? Should living arrangements, should moving out of the home? There seems to be a lack of understanding as well that, a separation can be one of the most dangerous times for victim survivors. And so this wasn't taken into account when considering the fact that it could be mitigating. Another important question the judges were asked about was, what happens when a complainant withdraws a complaint? And most judges agreed that that would be the end of the case. There's no statistics on this, and judges don't know why, but certainly when complaints are made in the circuit court and a victim withdraws their complaint, it is possible still to proceed. So this is a major area that requires greater understanding. I suppose the last kind of 2 important themes that I'm going to raise today is the importance of children as victims in their own right, I think there were certainly a cohort of judges who saw that the fact that children could be victims of domestic violence in their own right, and that even witnessing it could have long-term negative repercussions. But actually, not all judges were this well informed. I think some didn't fully appreciate that. All judges, on the other hand, were very aware of the child welfare concerns, but there definitely was a need, and some of them said they would refer to TUSLA, but there was definitely a lack of clarity about what the appropriate I suppose, channel was in terms of raising those concerns. So just to finish there, there's so many recommendations I can't really possibly go through them, but just to say the different types of recommendations. So a lot of them were the ones that are most relevant, because this is done for the Judicial Council, were those related to training and sentencing guidance for district court judges. But there were a lot of recommendations that are in appendices or in different parts that are related to changes, really, really important changes that need to happen in relation to legislative solutions for the Department of Justice to pursue policy solutions, training for the DPP, training for court service data, and changes in data collection. And just to give you an example there of one of the recommendations there, because it relates to trying to help them to see that, you know, that they can't just see it as an incidental model. They have to look at the course of conduct approach. So I'll just read this last one and then I think we'll be finished. Sentencing guidance for district court judges and how to approach the assessment of harm associated with psychological and emotional abuse, particularly when it's used as a method of control to gain dominance over a victim, and the circumstances in which the attempt to control the victim may be considered as an aggravating factor when sentencing Section 33 cases and all criminal cases involving domestic abuse. The guidance should highlight the need for assessment of harm to be informed by an understanding that domestic abuse can be understood as a course of conduct crime which prioritizes a wider consideration of the overall behaviour involved, rather than simply focusing only on the harm caused by the individual acts. So that's as much as I thought I would get done with you today. I'm glad to know I did get it done. So I welcome any questions.